Good morning. Good morning to you and welcome to the session Arbitration, Does the Seat Matter? My name is Nikolaus Pitkowitz and I have the pleasure and honor of moderating that session for you. Arbitration is the #1 dispute resolution mechanism for international disputes. Virtually all cross-border agreements have arbitration clauses, and there are many good reasons for that. Arbitration ensures worldwide enforceability, speed, confidentiality, just to name a few. Arbitration also has become a big business. The profits are not so much collected by arbitrators, even though they become increasingly busy and tour the world, and not so much by institutions. Many of those operate on a profit-driven or non-profit-driven aspects, but law firms, certainly, which have big teams working on arbitration, and more specifically also governments. A study by the ICC made some years ago has come to the result that the total cost of arbitration, out of these 2% go to the institutions, approximately 15% go to the arbitrators, and the remaining 82% are the parties' cost. And in 2012, Charles River Associates, an expert consultant seated in Toronto, Canada, has come to the result that for the city of Toronto in Canada, the total impact of arbitration on its economy for the year 2012 was 200 million euro. And that was based on approximately 425 arbitrations, with one arbitration having 475,000 euros each in cost, expenditure, total expenditure to the parties. So that's almost €500,000 per case. I can say now let's all move to Toronto. And in fact, many cities with that driving are very interested and anxious to promote themselves as venues for arbitration. And I just name, and I'm sure you have all seen the glossy brochures. New York, choose New York for international arbitration. We have one representative from New York sitting right next to me. Miami, a new center for international arbitration. Atlanta, a global dispute resolution center. And Moscow. I just wanted to show you also some statistics, and when you look at the different arbitration venues and the different institutional rules in more detail, and in particular also at the, as I say, a little bit exaggerating, advertisements being made. For a non-expert, it is very difficult to decide and to evaluate which criteria to apply. Which arbitration clause should I put in my contract? London, Paris, or Vienna? If I opt for Vienna, should I use the Vienna rules, should I use ICC, or should I use the UNCITRAL rules? So those are all difficult questions, and a simple answer to this, of course, is if you select one of the leading venues or leading arbitration institutions, you will most certainly be in good hands. In very good hands. And the more complex answer, and that is our topic today, is there are differences indeed. Differences in proceedings, differences in court supervision, and differences in cost, just to name three. Now, this panel of arbitration experts and some of the leading arbitration practitioners all around the world attempts to discuss with you those differences. And in strict alphabetical order, as under the name of the venues, we will have London, Moscow, New York. PCA, the representative of the PCA has not arrived yet. I think he was still speaking outside. Stockholm, Switzerland, and Vienna. And our program will be structured as follows. First, each speaker will have a maximum of 3 minutes, not more, to say a few words about the venue he's representing. And I will introduce each speaker as they speak. And then we will enter into a general discussion round in which we will debate a number of selected questions regarding venue selection. This will also then, at the end of the session, give you the opportunity to ask questions. It is a unique opportunity really to have representatives of so many different leading venues in front of you. Before we start with the speakers, I also wanted to shortly introduce two practitioners who have helped us prepare this panel and who are seated in the audience to give room to the panelists. The first is Peter Pettibone, former managing partner of Hogan and Hartson, now Hogan and Lovells, and of their Russian office, an independent advisor, expert and arbitrator, and dividing his time between Moscow and New York, as I understand. And the second one is Fyodor Vyacheslav, who is partner of Alrut law firm in Moscow and assistant lecturer and chair of the civil law in the Moscow State University, and also active member in the working group aimed at harmonizing legislation and court practice regarding international arbitration in Russia. Now, having said that, I would now give the floor to our first speaker, Professor Philip Kappa of White & Case, representing London, a very prominent arbitration venue indeed. London is actually, according to studies, one of which coincidentally prepared by White & Case, the world's leading arbitration venue. Philip Kappa is partner at White & Case in London. White & Case is one of the top arbitration firms worldwide. Philip is specialized in the field of engineering and construction, and he teaches arbitration and construction law at the King's College in London. Philip, the floor is yours.
Well, thank you very much, and good morning, ladies and gentlemen. It's a privilege to be with you here this morning. As our moderator has said, studies do indeed indicate that London is a very popular venue or seat for international arbitration. Why is that, and are there any issues? Well, first, let's look at the obvious reasons why a seat is popular. Does it have an arbitration-friendly law? Yes, it does. It has a modern Arbitration Act in 1996, which is consistent with the model law, consistent with the UNCITRAL model law, but offers many additional features, most of which enable the parties to have what they want. What about the courts? Are they supportive? The answer is that over the last 2 decades, at least, the English courts have become more and more supportive of the arbitration process. And so you will see that typically you get assistance from the courts during the process, and you get relatively little intervention from the courts after the process. In other words, you might summarize that as, in general, pro-arbitration, an arbitration-friendly court system. What about the legal infrastructure for arbitration beyond the law and the courts? Well, the institutions are present. In addition to the LCIA, there are many specialist sector bodies, especially in maritime and in commodities. And this is increasing also in the financial services field. The way the English Act works, the English arbitration law works, is to have a minimum of mandatory provisions and then a very considerable selection of optional provisions, some of which you have to contract out of, otherwise you get them by default, others that you contract into. It's a bit like a rather nice menu at a dinner. However, you have to make your selections correctly. If you choose LCIA, if you choose ICC, these work naturally to switch on and switch off the relevant provisions of the Act. In other words, the arbitration law facilitates choice of institutional arbitration, and you would get what you expect. You already know that London is a place where there is a great deal of other infrastructure, not only lawyers, but translators and experts and all the things that you would need for a successful arbitration. Are there any areas that you would not expect? Well, first of all, be aware that if the governing law of your dispute is English law, but only if it is English law, then you can, if you wish, have an appeal to the courts on a point of law, either as a preliminary issue during the proceedings or after the award. But you do not get that automatically if you choose institutional rules like LCI or ICC. But beware, if you choose your own rules, create your own rules, or choose, for example, the Stockholm Chamber rules when I last looked at them, they would not ordinarily switch off, because that's a provision you have to opt out of if you have English law. Other issues that we will perhaps come back to later, if there's a genuine question that you were never a party to an arbitration agreement, that could give rise to substantial litigation. So those early jurisdiction arguments that you were never a party could take you into the English courts quite readily. Costs in London are relatively high. I prefer to talk of value, as you might expect. A couple of final points. Confidentiality. The English legal system gives you a very high doctrine of confidentiality in regard to arbitration. But above all else in England, the contract you write is the contract you get. The legal system delivers what you write in your contract. And that's why you can see from recent cases like Dalla and Pakistan, or other recent cases on the law governing the arbitration agreement, Sul America from Brazil and Cruz City from India, that you can see an interesting tension at times between England's determination to give you your contract and some of the other policy issues that arise in arbitration. Enough from me for now. Thank you, moderator.
Thank you very much, Philip, for that really condensed overview. And we now move over to Alexei Kostin. Alexei is current president of the International Commercial Arbitration Court at the Russian Chamber of Commerce, and he's head of the private international civil law department at the Moscow State Institute for International Relations, and a person who certainly doesn't need any further introduction here and well known to all of you, and who will now introduce the Moscow situation. Alexei.
Thank you, Mr. Moderator. The most difficult question I had in mind, which language to use, and so it would seem that no of my partners here in this panel were no device for simultaneous interpretation. Well, some of the people are brilliant speakers in Russian. So, with your permission, I will continue in English, saying that «Доброе утро, я очень рад быть в Санкт-Петербурге, но буду рассказывать о Москве». So I said I'm very lucky to be in St. Petersburg.
But I will be talking about Moscow.
Moscow in the mini Russian Federation. So you know that there are plural permanent institutions in Russia, and under the unofficial statistics, there are some 2,000 or 3,000 permanent arbitration institutions, but worldwide known are very few. Those who are traditional old institutions attached to the chamber. Besides that was mentioned that I'm president of the ICAC, and this is our propaganda brochure, well, which was dedicated to the 80th anniversary. Last year we celebrated this very important for us, at least, period. And so this is one of the criterion to be taken into account, that, well, you can have many neophytes, new institutions which are trying to be very attractive. But, well, traditional way is to rely on which is stable, which can be proven by the previous practice. Stability, predictability are very good factors. Besides, at the Chamber, we have a Maritime Arbitration Commission established in 1930. It so happened that recently I became chairperson of this commission as well. We can handle these two commissions, the eldest institutions in Russia, can handle only international disputes. Therefore, under the Chamber, there is an arbitration court, the arbitration court, dealing with domestic disputes. Our caseload for some years is quite comparable to London, Stockholm, and some other. Well, perhaps we cannot compete clearly with ICC, since it's more international, has more resources. But just to give you a figure, last year we had 240 international cases. Last year we had over 300 new cases, and under circulation there are of course more cases. Confidentiality, yes. Well, the rules are not overcomplicated. We are very affordable in accordance, while taking into account the price. And my colleagues and myself, we believe that the core issue is good relationship between price and quality. I'm sorry to say that we are several times cheaper, in good sense, than ICC, twice or thrice than Stockholm, London, etc., etc. We have a recommendative list comprising 170 something arbitrators. 1/3 of them are foreigners, but the parties are free to choose any person which can be qualified as an arbitrator. The parties can choose any language. Only when the parties did not agree otherwise, Russian language would be used, but the interpretation, of course, can be provided under the expenses of the party requiring this interpretation. Legislation, and perhaps this is my final remark, unlike in London, beginning in the 90s, we, the lobbyists of the international commercial arbitration, took the different view. We just adopted the model law as it is. And we have the version of, still we have the version of the model law of 1985, but we already prepared the draft for amendments, for adaptation to the ancestral version of 2006, and the first reading of the State Duma already has passed, and we are, after passage of some time, are going to have the quite modern model law, and this is, well, tastes differ. Well, we think that for international community, it's important to have, I already told this, predictability. When you're asking, what is the regulation? You can use any text of the model law, official language of the United Nations. You took the English version, you took the French version, you took the Chinese, Arabic. There are some very small deviations which can be explained in 1 or 2 minutes if desired. That's all, perhaps. Thank you.
Thank you very much for that also extreme concise overview. And we now move to our next speaker, Hagit Elul. Hagit is partner at Hughes Hubbard Reed in New York, specializes in commercial disputes and arbitration, also served as expert witness for New York law abroad, and she is also a board member of the newly formed New York International Arbitration Center. And Hagit will now speak about New York.
Thank you, Nicholas. And I'm delighted to be here in Russia. This is the land of my grandparents, so it's a homecoming of sorts. And I want to thank Nicholas for all his work in putting together this panel. And I'm going to rely on him to poke me if I go more than my 3 minutes. Fortunately, in New York, we are very brief because time is money for us. So I'll get right to the point. New York is a very, very pro-arbitration venue. The United States has a very simple framework, statutory framework regarding arbitration. It's the Federal Arbitration Act. It's very simple and very efficient, and the basic premise of it is that parties' agreements to arbitrate will be strictly enforced. In all honesty, the courts in the U.S. welcome arbitrations because they're frankly too busy to handle all the very large commercial disputes that they get. So when faced with a situation where a court needs to enforce an arbitration agreement or enforce an award, the courts will do so efficiently, effectively, and summarily. And in addition, we're seeing a new trend where the courts are taking a very, very skeptical view of challenges, unfounded challenges to arbitration agreements and to arbitral awards, and will issue sanctions against both parties and their lawyers who take steps to make frivolous challenges. In the U.S., there is both a dual federal and state system. However, there is a uniformity of law concerning arbitration. International arbitration will be handled by the federal courts, and the United States Supreme Court is extremely active in ensuring that the federal policy in favor of arbitration is furthered. And so if a court steps out of bounds, the United States Supreme Court won't hesitate to go in there and correct the situation that's going on. There's also now a developing restatement of international arbitration that is being prepared by experts in the field, and that's, I think, now in its 7th draft. I've looked at it. It's an extremely well-developed description of the law of arbitration in the United States, and will certainly promote efficiency and predictability in the application of arbitration law, and that's to be published soon in the next year or so. In terms of logistical support for arbitration, I mean, New York has both the ICDR, it has the ICC, and the ICC is soon to be opening a secretariat in New York, but right now it's working through the USCIB there. And those are 2 administering bodies, but there's also others, including JAMS and CPR. And in addition, the newly formed New York Center for International Arbitration is devoted at providing a resource for people that are looking to arbitrate in New York. Now, we're not an administering body. We don't have rules, but we do have hearing rooms, beautiful hearing rooms that are set to open in June. And basically, we're here to answer any questions that any party may have about arbitrating in New York, whether it's where do I find translators, where can I get referrals for hotels, where can I get logistical support, or any of those other types of matters. And just to touch briefly on what we call soft factors as to why would anyone want to be in New York. It is a city that never sleeps. Although I sleep, I go to bed at 10 o'clock. I do understand from people that visit that they do have a good time. We have 60 Michelin-starred restaurants, including one that features English food, and then one that also features Swedish food. For the Russians out there, in Brooklyn, where I live, there's an area called Brighton Beach where you could spend weeks without having to speak English. So next time you're in New York, do contact me, and I'll make sure that you have a good time.
Thank you very much, Hagit. We now turn right over to the next speaker, who is Hans-Hugo Siebeles, who is the Secretary General of the PCA, the Permanent Court of Arbitration. I'm pleased you could make it in time to join us for your presentation about the PCA. Hans-Hugo has served as an ambassador for the Netherlands in France, Monaco, and Andorra prior to his position as the Secretary General of PCA, and is former director for the political affairs in the Ministry of Foreign Affairs. Now the floor is all yours, please, for 3 minutes only, unfortunately.
Thank you, Mr. Moderator. I apologize for arriving late. I was in the hands of another moderator who wouldn't want to let me go because there was a panel of the international institutions established in The Hague, of which the PCA is one, and almost the oldest one. As such, I'm glad that you mentioned my past, because it explains that as a diplomat, although with a background in public international law, I'm the person who knows a little bit about many subjects, but not very much about one particular subject. So I would be delighted to present some of the features of the PCA, and I'll try to do that inside the 3 minutes that you have granted me, sir. As you know, the PCA, it's a misnomer. It's neither permanent nor a court. It's a mechanism that provides for registry services, and also more recently the Secretary General of the PCA has been authorized under the UNCITRAL rules to act as an appointing authority, or as a designating authority for appointing authorities. The PCA is an intergovernmental organization counting 115 member states. We specialize in administering disputes involving public entities being state-controlled entities or intergovernmental organizations. Specifically, we act as registry in state-to-state arbitrations, of which we presently administer 6, in addition to that, in mixed arbitration, investor-state arbitration, of which we presently administer some 70, either under investment protection treaties or under commercial contracts, again involving at least one of the parties as a state or state entity. We are headquartered in The Hague, in that beautiful building that's called the Peace Palace. In fact, the Peace Palace was built for the Permanent Court of Arbitration, and it opened its doors in 1913, meaning that in another few months it will have its centennial in August, to be precise, during which period we organize a seminar dealing with the certain characteristics of investor-state arbitration. A panel moderated by Peter Tomka, with the keynote speaker John Paulson, and panelists like Brigitte Stern, James Crawford, and Chris Greenwood. However, being headquartered in The Hague and dealing with some of our cases at that location, the Peace Palace, we can administer arbitrations throughout the world, wherever most convenient, either in terms of hard factors or soft factors, as you have mentioned. So, with your permission, I would like to confine my further contribution piecemeal in terms of certain comments in relation to certain seats and certain jurisdictions as we have experienced them in recent cases. Thank you.
Thank you very much. Now, We are on the political side now, and we have another political speaker. This is Magnus Grana, who is the State Secretary to the Minister of Justice of Sweden and advises on new legislation projects. Magnus, however, has a attorney history. He was partner in one of the leading Swedish law firms prior to becoming a politician, and he will now speak about Stockholm, Sweden, and I assume some political aspects in the venue selection process. Please, Magnus.
Thank you, Chair. Well, the question asked is, does the seat matter? And I think I'll be bold enough and self-confident enough from the Swedish government to say, yes, we believe it does, and we really hope it does. Because at the end of the day, from a regulator's perspective, and that will be obviously my perspective, we are trying to do everything possible to make arbitration easier. And we've heard examples, obviously, from other countries as well. I can give you the Swedish story. I think it's important to understand from a regulator's perspective that international arbitration contributes to, at the end, economic growth and development. That's the key factor. That's the reason for regulators to get involved in this issue. The interconnection at the end of the day between the rule of law and economic growth has long been recognized by international community, and it is a focus point for many governments. I think looking back at the development the last decades, when arbitration has grown, I think it's fair to say, and I'll get back to two examples of that, that Sweden and Swedish arbitration has come to play an important role in developing. So why Sweden? I'll give you a few examples, and I know that my good friend Professor Hober will continue with further examples after my short speech. I think looking at it from a regulator's perspective, we see that Sweden has a long tradition of alternative dispute resolution. Actually, arbitration finds can be found in Swedish statutory law as early as the Middle Ages. So we've been doing this for quite some time. In addition, Sweden as a nation over the years has developed a position of a free trading, export-dependent country with a strong international presence. And of course, we have a neutral jurisdiction and independent and arbitration-friendly court system. I think the early international recognition of Sweden expertise and Swedish legal framework for arbitrators is best illustrated by the so-called optional clause agreement concluded in 1977 between the American Bar Association and the USSR Chamber of Commerce and Industry. By this agreement, the parties from the United States and Soviet Union agreed to recognize Sweden as a neutral venue for dispute resolution in international trade between the two countries. In recent years, Sweden has also emerged as a preferred venue for investor-state arbitration under international law. Today, at least 121 bilateral and multilateral investment treaties refer investor-state disputes to the rules of the Stockholm Chamber of Commerce. As a result, the SEC rules is today the third most commonly used set of rules for investor-state arbitration in a global perspective. We are also happy to see that the Stockholm Chamber of Commerce is part of the Energy Charter Treaty as one of three options for investor-state dispute resolution. So what makes Sweden attractive? What is our selling points? To begin with, arbitration in Sweden puts a strong emphasis on the principle of party autonomy and equally fundamental principles of due process as reflected in the Swedish Arbitration Act. Parties are essentially free to structure the arbitration in Sweden as they see fit. The Swedish Act on arbitration, in turn, rests on the same principles as the UNCITRAL model law on commercial arbitration. Sweden's procedural traditions may be described as particularly suitable for international arbitration, being a combination of continental European civil law and common law traditions. The procedure is adversarial. The parties are essentially controlling the facts and evidence to be introduced. In particular, examination of witnesses, is conducted by counsel for the parties. On matter of evidence, including the disclosure or production of documents, Swedish law reflects best practices in international arbitration as is in general in line with the IBA rules on taking of evidence. Of course, when matters move on from arbitration to courts, Swedish court system is swift, impartial, effective, and all that. I'm sure you know all that. Presently, obviously, as many governments, we are planning for a committee of inquiry to further strengthen the Swedish arbitration legislation and to further expedite the Swedish court procedure on arbitration matters. However, we don't expect any big changes because over and all, we believe that the Swedish system as present is a viable and in par with international best practices. So in summary, Sweden is firmly committed, the Swedish government is firmly committed to, and we are actively defending our position as a top venue for arbitration. And Stockholm is ready, Sweden is ready to meet the need of business, present and future. For a politician, I think that's quite quick.
Yes, indeed. Thank you so much. We now turn to Professor Kai Robert. Kai is partner at Mannheimer Swartling, a leading Swedish law firm. He teaches at the University for International Investment and Trade Law at Uppsala. He's board member of the Arbitration Institute of the Stockholm Chamber of Commerce. He's fluent in Russian and probably the best known Swedish arbitrator worldwide, and I must say, having experienced him as a chair in proceedings, really one of the best arbitrators in the world. So very pleased to have you here, Kai, and give us some more information about Sweden.
Thank you very much, Niklas, for that very kind introduction. I really don't have anything to add at this point. I mean, in the interest of time, I think we should move on with the other issues, and I will come back to when we come to specific issues. Thank you.
Very good. Thank you. Dominique Brown-Burset, partner at Brown & Page in Geneva, a law firm specialized in dispute resolution, one of the leading Swiss arbitration practitioners, and that is important to add, also president of the executive board of Arbitral Women. Dominique, please.
Thank you, Nicholas. I'm also extremely happy to be with you in this beautiful city that I start to discover, and I hope I will come back very often. Switzerland has a long tradition of arbitration, like Sweden, like England, like everything I already heard. In my city, in Geneva, there is a room which has become known as the Alabama Room, which is very famous, and it was the seat of one of the first major important international arbitration in 1872 between the United States and England. And it is considered like perhaps the case which gave rise to what international arbitration became later. This case was turned around whether England had infringed its neutrality obligations by allowing the warship Alabama and several other to be built and fitted out of England, knowing that they would be sold to the Confederate States of America, and if so, whether the United States was entitled to damages for the US ships sunk by those warships. That was during a very tense period in the American history. It was remarkable that an agreement was reached through a treaty already in Washington, which opted for arbitration to resolve this matter. And because of the reputation of Switzerland for neutrality, this arbitration took place in Switzerland. And because of its reputation for international matters, also probably there. The award was issued by a tribunal of 5 members, there was five members. Yes, there was a Swiss, a Brazilian, American, English. I'm missing one now. I will have to check again. And it was issued by a majority of 4 in favor of the United States on September 14, 1872. The hearing was supposed to be in English, but the deliberation and the papers are all in French, so it was already a very international matter. Through Johnny Wieder, who is well known, I suppose most of you know him, QC, with whom I sat in another case last week. I know, because he went to research the archive during the week there, that he was himself surprised to see that the representative of England and the US also deposited their notes in French for the archive. So it was a very truly international case. England was sentenced to pay 15.5 million in gold, which was a lot of money at the time, to the US, and I understand it did. So from then on, things have developed, and we host a huge number of cases. Many of them are not in the statistics. Many cases are ad hoc cases, that is, cases which are not administered under any specific organization, and which are tailor-made specifically for the parties who have a dispute. This happens a lot between states and state entities. I'm involved in several of these cases, and you will never see them listed anywhere, and nobody's going to talk about it because confidentiality is really kept, and this is the reason why these parties come, actually. On the other hand, end of the spectrum, we have developed special skills, I think, in high-tech, telecom. There are many telecom cases, including cases relating to this country, which were heard in Switzerland. We also, as probably most of you know, host the Court of how is it called? CAS, the Court of Arbitration in Sport, since 1983. And this court is extremely active. There are more than 400 cases filed, requests for arbitration every day. They are not in not every day, I'm happy to say every year. They are not in the statistics. And as you probably know, for each Olympics, there is a division of CAS which goes to the site of the Olympics. So it will be in your country for the Winter Olympics. And they resolve any dispute between athletes and federation, anything linked to the Olympics within 24 hours, pursuant to Swiss arbitration law, which is our Chapter 12 of our PIL Act. And although the Olympics, the next Olympics, will be in Russia, the winter ones, the seat of these arbitration will be considered to be in Lausanne, in Switzerland. So for any dispute, in case there is a challenge, somebody is going to have to come or call someone in Switzerland to try to challenge this award. And the challenge goes straight to our Supreme Court. There are very few grounds for appeal, which are essentially due process and very breach of the right to be heard. The Swiss Supreme Court is extremely strict about challenges and very rarely accept them. I think the latest statistics say that only in 7% of the cases challenges were upheld. And interestingly, in the last couple of years, most of the cases in which the challenges were successful were relating to sport arbitration and CAS decision, either relating to cycling or horse riding, you name it. One of the big advantages of having Swiss law of arbitration applying to arbitration, to the Olympics, for instance, is that we have an extremely broad concept of arbitrability. Anything which is of a pecuniary nature, says the law, is arbitrable, which basically means almost everything. It's very rare that any case would be considered as not arbitrable. Without going into the details we are going to discuss further, Nicolas, I would just say that perhaps the reason why Switzerland is still a very popular seat for arbitration has also to do, I think, with its legal practitioner. Because we have 4 languages, we are trained to read cases in different languages. We have a very strong tradition of comparative law, which I think is a key ingredient in international arbitration. It's not only about speaking the language, knowing the 3-star restaurants where you go, in the city you go. It's really a matter also of having your brains used to being open to the law of a different culture and try to integrate that in the solution that one has to find. So a very cosmopolitan bar, which probably explains also the reasons why so many of the main, even though we don't have big firms, we still have quite a lot of practitioners who are well known worldwide in this field and who have become excellent arbitrators, probably because of this experience.
Okay, well, thank you very much, Dominique. We now turn to the last seat to be presented. This is Vienna by Dr. Manfred Haider. Manfred Haider is, since 2001, Secretary General of VIAG, the Vienna International Arbitral Center. He teaches law at the University of Vienna. He formerly served as Secretary General at the Vienna Stock Exchange Arbitration Board and also has experience as a practicing attorney. Manfred, the floor is yours now.
Thank you, Nikolaus. As we are now 200% over time, according to your schedule, I will refrain from bringing forward legal arguments why Vienna is obviously a very popular venue of arbitration. I will instead talk about politics and about the soft facts. First, politics. Austria is a neutral country like Switzerland, although our Swiss friends have a much longer tradition in that field. But however, a neutral country is a place where parties from different political systems can easier meet than in centers of the given ideology. And it is no incidence that the Vienna International Arbitral Center, that's the institution I'm working with, is a child of the Cold War. The American Arbitration Association and several chambers of commerce of the countries, of the member countries of the Council for Mutual Economic Aid were in search of a neutral venue to arbitrate their disputes. As we have heard from Mr. Graner, Stockholm was the recommended place in a trilateral agreement between the Chamber of Commerce of the Soviet Union, the American Arbitration Association, and the Stockholm Chamber of Commerce. A similar situation happened to be in Vienna, where similar trilateral agreements with several other Eastern and Central European countries were concluded. Although there are no declared political blocs anymore, this tradition is still alive. The next thing I want to talk about is that pursuant to a recent study of the ICC, Vienna holds the 5th rank as a preferred venue of arbitration in Europe. The other cities are London, Paris, Geneva, and Zurich. And what is also mentioned in that study, that only Singapore crowds out Vienna from the 5th rank on a worldwide, on a global view. What also plays a role, in my opinion, is that Vienna is a financial center for Central and Eastern Europe. So it is similar to London and to New York, however, much lesser in size, of course. But this seems to have also an impact on the choice of the venue of arbitration. Last but not least, I have also to add that Vienna is the 3rd official seat of the United Nations. It's the home of UNCITRAL. My institution was a founding partner of the largest student competition in the field of international arbitration, of the Wismut. And the very final argument is that Austria enjoys a very high quality of living. Vienna is a city that sleeps, in contrary to New York. But I borrow a saying from Dr. Samuel Johnson: if a man is tired of Vienna, he is tired of life.
Thank you very much for that, Manfred. And now, before we enter into the question and answer round, where we will be discussing specific aspects about venues, and where each of the panelists may be grilled with questions, I would just like to introduce to you the venue selection criteria. As you already heard, we've divided them into hard facts and soft facts. Hard facts are tangible, easily comparable. The soft facts, not so easy, but some very often also referred to, as you heard today, like the quality of the restaurants or living qualities. Now, and those count. If you look at offices, if a new company selects a new office location, there is usually a list of 10 criteria, which are all specifically listed hard facts. And then there is a criteria number 11. Where does the general manager live, and where does the general manager want to go? And that is a soft fact, which is often much more important in practice than the 10 hard facts. So I think it's important to also address the soft facts when we look at venue selection. People like to travel to Stockholm, they like to travel to London, they like to travel to Vienna, to Geneva. So I think that is one of the reasons why these cities, which are some of the most livable cities in the world, have become so popular also as arbitration venues. Now, when you look at the factors, and I here refer again to the study, which that's the Queen Mary White and Case study of 2010, which has done a very detailed and informative, in-depth survey about these facts. And the number one criteria, hard fact, which companies apply is the general formal legal infrastructure. For 62%, that is the most important aspect. What does that mean? That means, first and foremost, neutrality and impartiality. We've heard about that a lot today. Second, arbitration friendliness. We've heard about that also. That includes national arbitration laws, the track record of courts enforcing agreements to arbitrate and arbitral awards, whether it is a signatory to the New York Convention, which almost any country in the world is, whether its law is based on the ancestral model law, but also other factors like ability to join third parties, availability of appeals against awards. And the basic concept parties have is that they first exclude venues which are not neutral and impartial, which is usually the home country of the parties of the dispute, and then they try and find the most arbitration-friendly country. The second most important criteria is the law governing the substance of the dispute. That is something we're not addressing here in more detail. The third is general infrastructure and cost. Cost is by far the most important factor here. 42% mentioned that as a decisive factor. But of course, good infrastructure, good transportation, hearing facilities, interpreters, translators, safety and absence from bribery are those factors which are being named. And out of the soft factors, in the interest of time, I just want to mention convenience. Convenience is considered to be a very important aspect, the efficiency and promptness of the court proceedings, the language skills, established contacts with local lawyers, availability of lawyers, law firms, location of the parties, cultural familiarity, like in Brighton Beach, in Brooklyn. Surprising one point is that the previous experience in a hearing place is only a very, very low, only 7% of the people questioned said that their previous experience is decisive. And understandingly also not so important is the location of the arbitrators, because the arbitrators travel all around. And you find some more soft factors on the slide. But with that, I would now like to move to our round of discussions and address the first on the general legal infrastructure and put the word here to our panelists, the arbitrability. Arbitrability is the ability of a matter to be subject of arbitration agreement and arbitration proceedings. And there are restrictions, and I just want to find out from our panelists where restrictions lie. And I'm just addressing one sensitive issue, corporate disputes. Are corporate disputes unrestricted, arbitrable in your jurisdictions? Are there problems, or do you see any other disputes where restrictions are? So who wants to speak first on that topic? Kai.
Thank you. Well, generally speaking, under Swedish law, the test of arbitrability is whether or not the parties can reach a settlement on that particular issue, which means, of course, that all commercial disputes are arbitrable. The traditional exceptions in our system and in most other systems are patents, trademarks, and things like that. And when it comes to corporate disputes, I think one has to be a bit careful in using that term because it can cover a lot of different kinds of disputes. But if we focus on, let's say, shareholders' disputes, which is a hot topic, particularly in this country, I think in Sweden it's no doubt that they are arbitrable, as I would think in most other countries in Western Europe anyway, because these disputes are based on a contract. The contract is based on the will of the parties, so any dispute under that shareholders' agreement would be arbitrable. There are, however, certain other disputes, sort of, that you could perhaps qualify as corporate disputes, dealing with the internal mechanism, if you will, of a shareholder or joint stock company or something like that, and some of those would not be arbitrable, but you would have to challenge them. I mean, a decision, let's say, by a general shareholders meeting, if you want to challenge that decision, you have to do that in court. But in every so-called corporate dispute which is based on a contract is arbitrable. And I think if I may add that with respect to Russian law, I think many, or at least some Russian lawyers do not make this distinction between horizontal legal relationships, i.e. contracts, and vertical legal relationships, which is the company's relation to the regulatory scheme in place. The fact that you have a certain outcome under a shareholders agreement dispute does not, in our view, actually affect the regulatory scheme at all. It remains in place. So you have one system at the horizontal level, another one at the vertical level. So to make a long story short, in Sweden, corporate disputes are by and large arbitrable.
Alexei, you wanted to add something on the Russian situation. There has been some case law, I understand, in Russia in that respect.
I'm always willing to say something, but I'm afraid of timing. But anyway, Kai very generously referred to our not simple situation, unlike Sweden. But we are lawyers here, and under the Russian law, any civil law dispute can be arbitrable unless otherwise provided by a specific federal law. We have only one federal law on bankruptcy, which clearly says that bankruptcy cases are not arbitrable. Therefore, traditional arbitrators, I'm not speaking about state arbitrage judges, they view that these matters are arbitrable, no big problem. We still are combating, many lawyers are of this view, but the system of the state arbitrage courts says that corporate disputes, nevertheless, are not arbitrable. Why so? Very simple. There is a specific article, number or something, saying that this is the exclusive jurisdiction of state arbitrage courts, commercial courts. But already in May 2010, the Constitutional Court saw a complaint by the high state arbitrage courts with reference to the same situation with real estate disputes, and said that reference in the arbitrage procedural code to exclusive jurisdiction makes a demarcation between state courts and does not touch upon arbitrability with regard to traditional arbitration. Mutatis mutandis, this has to be said about corporate disputes. But and I think after a while there can inevitably cannot be another solution, since the Constitutional Court had the final word about this pretext. Thank you. I could, of course, talk very much, but just to stop here.
Thank you.
Could I just add, sorry, one comment to you, Alexei, and I think you would agree that the let's call it the intellectual mistake that the arbitrage courts do or make is that they equate exclusive jurisdiction with arbitrability. And of course, these are two completely separate things.
We have not to that topic. When we don't have topic answers from other speakers, that means there is no issue, and I understand there is no issue of arbitrability of shareholders dispute in London, which applies, like Austria, a wider test than just a settlement, a pecuniary nature test. no issue in New York, no issue in Sweden, but Manfred Heider wanted to make a remark for Austria.
Just a short remark. In large public companies, it's not usual to have an arbitration clause in the bylaws, but in Austria as well as in Switzerland, mainly affluent people may make a foundation to depersonalize their wealth. And there will be a board of that foundation, and there will be people who benefit from the earnings of the foundation. And the disputes between either the founder and on the other side the board, or between the foundation and those who benefit from it, there are many disputes, and it's very popular to arbitrate those disputes, and it's even more popular to arbitrate those disputes on an ad hoc basis, because this gives obviously even a higher degree of confidentiality.
Thank you. I'm now turning, we all heard that there are very little mandatory provisions in local countries, so I don't think it's worthwhile addressing that in more detail. But what I want to address, and this is maybe something for Philip to respond to, is the common law, civil law divide. Does it make a difference if you're from a civil law jurisdiction, if you're arbitrating in a common law jurisdiction? I'm addressing that to Philip because he's the only, sorry, Hagit as well, but we have two common lawyers here on board, but maybe Philip, you want to address that first, and then one civil lawyer, whether there is a difference in the legal infrastructure from a common law or civil law perspective.
In principle, there is no difference. In everyday practice, there is a difference because of the experience of the players. So it's not a mandatory difference or a regulatory difference, but it comes from people's experience. So one can have in London a successful arbitration seated in London, not English language, not English law, no connection with English, no English in the tribunal, and they will have a very normal Swiss or South American or Asian arbitration. If, however, the parties start to engage with the ex-judges who sit as arbitrators, or the practitioners who are very often in the English state courts as well, there can arise an assumption that English styles of procedure are very good procedures, so why do we not adopt them? What I can tell you is normally arbitrations in London which involve some English participants, even only as counsel, will probably have witness statements, they will probably have cross-examination, they will probably have post-hearing submissions, and there will be a very strong emphasis on impartiality of the tribunal. No question of ex parte communications between the parties and the tribunal, for example. I think you probably think those are common law influences. They're also rather good practice, and I have to say that they are becoming widely adopted.
Dominique?
I totally agree with what Philip said, and the same could apply in a civil law country. I think the main difference with what really changes is the experience of counsel. Whether they sit in London, Geneva, Stockholm, or Singapore is going to be the same thing, and they can rely generally on a good legal infrastructure. But then they come with their own baggage and their own habits, and sometimes they forget about where they sit. And I see quite often Swiss-seated cases, an arbitration clause with a seat in Switzerland, carried out totally the arbitration in England because only big, large Anglo-Saxon law firms are involved. And then everything is going well. This Swiss arbitration case is perfectly run from London. And suddenly, sometimes at the end, there is a problem because they all forgot that the seat was actually in Switzerland. So it's always at the end of the case that the question arises, and it's always before the award the issue of cost. And we have very different, legal, civil lawyers and Anglo-Saxon lawyers, I think, have different experience about cost. And in England, costs follow events, so it's almost a rule. I think it is a rule in court. I'm not sure I speak. Yeah, in state courts, but some lawyers think it is also applicable in arbitration. And we don't have that like in most civil law countries. So then you have lots of discussions because these cases usually are very large and the costs are very, very long, very, very high. So it's interesting to see it's only at this practical level that somebody suddenly remembers that the seat is actually not in London. And the second point is, of course, after you have the award, because then you cannot go to apply for a challenge of the award if there is a ground for that in England. You have to go to the concerned country.
Thank you. I think arguably the most important factor in any arbitration is the arbitrator. And it does make, in my experience, if I just add a difference if there is a common or civil law trained arbitrator, because common law arbitrators usually will have a more adversarial approach, and civil law tend to a more inquisitorial. Everybody has the backpack of his legal educations to some extent with him, even though at the level of international arbitration there's a lot of convergence, but there are still some differences. Now, moving on to the next issue, look into the future. Can each of you tell us very shortly what next legal developments are being planned, what the governments are doing to improve the status of a venue, what legislations, what institutions are being doing? Who wants to start with that? Yes, please. Hans.
Well, thank you. I'd like to call your attention to a particular feature that I think fits best with this chapter on general legal infrastructure, look into the future. That is the issue of the status of the arbitrators and participants in arbitration. At our headquarters in The Hague, we have an agreement with the Netherlands pursuant to which parties in arbitral tribunals proceedings, that is both arbitrators, counsel, witnesses, experts, and so on, receive the benefits of certain privileges and immunities during any proceedings on Dutch soil. And arbitrators in particular have the status similar to diplomatic agents. In fact, the PCA is in the process of trying to establish with a number of its member states similar arrangements. At present, we have some 10 member states that have accorded the PCA such similar privileges and immunities. That is India, South Africa, Lebanon, Chile, Argentina, Costa Rica, Mauritius, and I'm forgetting certainly one or two. But we're in the process of further extending this network with countries like China and Peru, and in fact we're also in discussion with the authorities in Vienna in that respect. So that would allow us to provide for arbitrations conducted under PCA auspices in those countries, the kind of status that would allow arbitrators and others to enjoy a certain status that might be quite interesting from their perspective. Thank you.
Thank you. That's an interesting aspect. Kai, please.
Well, what about the future in Stockholm or in Sweden? Well, as we heard Mr. Grane say, the government is planning to review the Arbitration Act, which is not old. It was adopted in 1999. But things have developed in the world of arbitration, so I think we will try to amend and adapt to make it even more efficient and more adapted and suitable to international disputes. One thing I hope Mr. Grane will include looking at the courts, I mean, hopefully to streamline what the courts do with respect to challenges, even though the Svea Court of Appeal in Stockholm, I think one has to say, is doing a very good job. There is still improvement, I think, there. And there might be ideas of speeding that up somehow, because I think we all know, sitting in this panel, all of us know that arbitrations nowadays, irrespective of where you are almost, are rather streamlined as far as the arbitral process is concerned. I think the distinguishing feature comes after the award, really the challenge procedures. I mean, what happens in the courts of a particular country. And I think what we will try to look at in Sweden is to perhaps improve that part of the arbitration process even more.
Hagit, you already mentioned the restatement, which is planned for New York, so I think that I pass on right to Dominique. Any changes planned for Switzerland?
No. Well, I think the PIL Act was amended once since 1981, and it had to do with lease pendants to avoid that party would try to escape arbitration by starting court proceedings abroad. And now we have a specific provision stating that even if there is a case pending, the arbitrator can still look at his or her own competence. It's an extension of the competence. There are discussions now as to whether we should sort of clean up the act to make it even more arbitration friendly. If possible. There are also discussions and in some circles criticism of the Supreme Court for its very restrictive case law on challenges. It's interesting that, you know, when the PIL Act was adopted, the idea in Europe was one should have very limited ground for challenges, and state courts should really also be restrictive when applying them. Because we go straight to the Supreme Court, because we have so many cases, because there are quite a lot of application to set aside, put to the court, because they are very busy Supreme Court judges, they have really set on a very restrictive course of case law, and they try to close it every time. And it's only in sport law, as I said, generally, that they have accepted challenges, and because it has to do often with the key concept of whether the party, the sportsman or woman, had really accepted arbitration in a knowing way. Because as you maybe know, there are federations which refer cases to CAS, and in some cases it was not that clear. So they look at really the basic of arbitration. And a recent case that I saw actually on Monday, it was a Swiss case. It's a typical case we discussed. It was a Swiss rule case, seat in Switzerland, run in London with a sole arbitrator, English QC. And it's very rare that this happened, but in his award, he disregarded some skeleton arguments produced by one of the parties during the hearing. And on one aspect of the calculation of damages, this would have changed. It was the margin of the product in question, which had not been supplied. And it's very interesting that in that case, and I don't know whether it was because the arbitrator did everything from London or not, but the Supreme Court set aside this decision, which is very rare. And it's also perhaps in response to the criticism of those who say that, you know, if you have very few grounds, at least the parties are entitled to exercise their right under the law and raise this ground for challenge, and the court should not just be so restrictive. That's the only currently discussed topics.
Thank you very much. Alexei, from institutional or legal perspective, anything?
Both would be a permission. I don't think that there would be very many changes as to the international arbitration. I draw my attention that we are speaking about arbitration, but really we need to speak about international arbitration, where cities matter. So There is, and yesterday Mr. Prime Minister Medvedev said that arbitration courts are not in the very best or good shape, etc., etc. We think that it concerns mostly to the many domestic courts which are in thousands, etc., etc., sometimes established for not good purposes. But here we still are in the trend to maintain the very close link with the model law. We need to be the country of the model law to, to attract more attention. So in this way, we are trying to be cosmopolitan. I agree with Guy. Well, if you look into the rules of this present institution or other decent institutions, basically, well, there are many similarities and basic principles are the same. Of course, well, English people say, well, devil is in details. That is correct. But international arbitration in the tribunal, it is my firm belief and experience, they can find a way to make the process truly international, having regard to the applicable law, procedural, substantive, but to find the international way of, and therefore, the important issue is to have the best tribunal, to have the, and this is, in my opinion, one of the most important questions. The procedure shall not be overburdened and very complicated. Well, the tribunals and the institutions shall be affordable to the businesses. And that's why, well, if we go in this direction, well, convergence, etc., so the soft factors, Mr. Pitkovich, would have a greater impact. Convenience, well, many spoke about convenience of Vienna, well, Zurich, Geneva, Lausanne, that's fine. New York, Brooklyn, that's fine. Well, just not forget about Moscow, St. Petersburg, and some other many places in our not a tiny country. So sometimes these soft factors might be an attractive element to choose, well, an arbitration seat in Russia. Thank you.
Thank you. So you're promoting also Siberia and other. Manfred Heider
just two words. First one, new Vienna rules, which come into force by 1st July 2013, this year. And second one, Tuesday this week, a draft amendment to the Austrian Arbitration Act passed the Council of Ministers, and the most important issue of which will be that the action to set aside an award shall be brought in directly at the Austrian Supreme Court, who will then decide as first and last instance.
Thank you. Philip?
Very briefly, there are new LCIA rules in preparation, which will be published very soon, and will no doubt reflect the sorts of modernization examples that you've seen also in the ICC rules of the year before last. The English State Commercial Court has become very, very efficient, quick, and has a very strong control on costs. That influence, I think, will encourage similar processes in London-based arbitrations. That's to say, you will expect to see the same kind of rapid approach to case management and methods for controlling cost. Indeed, they've just changed the court rules to make even more difficult challenges on awards. That's to say, to speed up the process. Final soft factor, electronic trials, electronic materials, paperless hearings, bundles of evidence, all dealt with electronically, is becoming now very significant in the marketplace, and it's very easy to do in arbitration, and we're seeing that a lot.
Well, we have a few minutes left, and I would now like to open the floor for any questions we have from the audience. Of course, we could go on in that really interesting debate for hours, and I think some of the speakers are still available for questions afterwards, but we have Ilya, you raised your hand first, please.
My name is Ilya Nikiforov, managing partner of the group against partners. The question is, I think moderator and panelists have mentioned that cost may be an important factor in determining the place of arbitration. Now, the question to any of the panelists who may answer is, who may want to address it is, to what extent choice of the place of arbitration may influence VAT, value-added tax obligations of the parties, because as you know, in international arbitration, sometimes you pay foreign VAT which you cannot even offset against your national tax obligations, and it increases all the costs you pay to arbitrators and so on by, I don't know, 15 to 30%. Thanks.
So the question was, when you look at cost, how much, to what extent do you look at VAT?
To what extent the place may influence VAT other than the nationality of the
place? Do you have, is there any place, just speaking for Austria, I think in most cases VAT can be deducted if you properly do it. Are there any places where people end up paying the VAT at the very end, which is your concern, any arbitration venues? Kai?
I don't know, but I'm going to answer the question, namely, I think that most, where my attorneys had, I think when you look at the place of arbitration, that consideration plays a very, very, very small role. That's my experience anyway.
In Switzerland, Swiss arbitrators do not pay VAT, so it's reflected on the parties, and counsel who do work for non-Swiss based clients do not the work is also VAT exempted.
And the position in England is almost identical to that that's just been described in Switzerland.
But it can be a problem if you don't address it, and I've had cases in the past where it was a problem if it wasn't properly addressed, so it's important to address it from the outset. There was another question, yeah?
Anton Asoskov-Lomonosov, Moscow State University. Let me ask a question which relates to the division, also to the division between common law jurisdictions and civil law jurisdictions, and it relates to such interim remedies as anti-suit injunctions. I think many of you know that here in Russia we have a serious problem when many Russian companies being respondents in international arbitration, they're trying to block future potential enforcement of international arbitral awards by commencing parallel proceedings in Russian courts trying to invalidate, for example, the underlying transaction. And my question is, do you think that ability of the state courts in the place of arbitration to grant such interim measures and as anti-suit injunction is a really serious advantage? And in particular, it would be interesting for me to understand the position of the representatives of civil law jurisdictions. So what you think about such a potential advantage of the common law jurisdictions? Thank you.
So which civil law jurisdiction wants to go first in promoting something which civil law jurisdictions typically do not have anti-suit injunctions? Yeah?
Well, of course, that concept is alien to most civil law countries. As far as Sweden is concerned, whatever happens in the arbitration in Sweden cannot be influenced by any court in any other country, basically, while the arbitration is going on. But that is not the problem, as you point out. The problem will come at the enforcement stage, because if the Russian respondent has run to court here and the non-Russian claimant has won, I mean, he will have a hard time enforcing the award here in Russia. What happens, of course, today is that people look for assets outside Russia. But I think the real problem is here, in my example. I mean, Russian courts should really pay respect to the arbitration agreement. So if a contract has an arbitration clause, that clause must be respected also by Russian courts. And not as, I mean, the typical argument, of course, of the Russian company in my example is to say the contract is invalid and therefore there is no arbitration clause. I mean, as we all know, that should be a non-starter because of the doctrine of separability. So I think the first thing to do really is to make sure, however you do it, I don't know, but that Russian courts actually pay respect to the arbitration clause. Then, of course, there are certain aspects of Russian law, and Alexei, correct me if I'm wrong, which actually means that a third party, so-called, can actually file a suit in Russian court asking for the invalidation of the arbitration agreement, even though he or that party is not a party to the contract, which again, from an arbitration perspective, is really an anomaly, shouldn't be accepted in my view. So I think from a civil law perspective, that's where you should start trying to fix the problem.
Well, with that, we have unfortunately, very sorry about this, run out of time and concluded our session. We have covered a lot of topics. We had a very interesting debate, and I would like to thank you all for listening to us, and also thank all of the panelists for being so precise, concise, and informative on that really interesting topic. Thank you all again.